The number one reason is usually called neglect, but of course that can be a lot of different things. It can be a parent who leaves a small child alone for a long period of time, or it can be somebody who does something in their caretaking of a child that the state thinks is wrong, that some of the rest of us might not think is wrong. So it's child neglect happens more than child abuse, but what child neglect is obviously subject to debate. Abuse is usually the direct physical harm to a child caused by somebody hitting them or otherwise touching them in ways that are inappropriate. And obviously sexual abuse involves a sexual conduct of some kind. Whereas neglect is kind of the failure to do things as a parent, the failure to provide food, the failure to supervise the child, the failure to do something else that a child needs. Reasonable cause to believe that abuse and neglect may have happened. It doesn't even need to be likely that it happened. It just needs to be very possible that it happened. And there's a debate all the time about how much proof that requires. But to shatter a family in that way probably requires much less proof than it does to hold somebody guilty of a crime or possibly even to win a lawsuit against somebody. It's a pretty flexible and I would say sometimes fuzzy standard. Typically they go to a foster home. Sometimes in the very beginning they go to some kind of an emergency shelter or institution. But the preference is to have them go to a foster home. Dcfs is required to try to find foster homes with relatives if possible. But that's not always possible, and then they'll go to a licensed foster home of some other kind. Some kids do go to shelters or institutions, and typically those are hired by Dcfs. They're private agencies, and Dcfs pays them to take a child for a short period of time or sometimes a longer period of time. Well, in theory, a service plan addresses the reasons why the child was removed and addresses anything else about the child's needs that's necessary. So, for example, a child may have special medical needs. A child that was abused may need to seek medical help of some kind. And so the service plan basically, it can do more, but basically does two things. One is, if the plan is to return the child home, it addresses, in theory, the things that are necessary to make the home safe and stable so the child can go back. And then secondly, it addresses whatever other needs the child has for health care, education, etc. Well, there certainly are some services that families receive and that children receive that benefit them. I think far too often service plans, particularly the plans directed at parents, are rituals of compliance where they require a parent to go to a parenting class that really doesn't help them. They require the family to go to counseling, which may or may not be something that helps them to deal with the challenge that brought the child into care. So I think some of these things are more tests of obedience, so you can see, the court and Dcfs can see if a family's doing what they're told. And then if they are, they might get a child back, and if they aren't, they might not. And those things often don't have a whole lot to do with whether the home is a safe and stable place for a child, which ought to be the real question. Sometimes a parent who really unfairly lost custody of a child is angry and doesn't do what they were told. But that anger might be the very thing that reflects why they are a good parent, why they care about their child. Somebody else who's kind of compliant but inept at being a parent, might go to the class and learn nothing, and they might get the child back. So in fairness to Dcfs, it's very hard to judge whether somebody can provide an appropriate home for a child, particularly where there has been a serious problem of abuse or neglect. And we don't really know what to do about that. But a lot of the so-called services, in my view, really don't help people very much. until they're 21. When they're 18, a court has to enter an order keeping a child in custody. And in Cook County in particular, courts are fairly willing to do that, less so outside of Cook County. But in theory, a child can stay in the system until 21. And for children who stay in for a long time, it's often not a great life. And it's something we try to prevent if we can. In theory, Dcfs is supposed to provide some services to help with the transition. And even before the transition, there's independent living programs and other programs that are supposed to help a child get ready for independence. But we know that having a bureaucracy as a parent doesn't really prepare you for adulthood very well. And there's studies by the Chapin Hall Center for Children at the University of Chicago and others that show that a very high percentage of children who exit foster care end up homeless, end up unemployed, end up in prison, end up with serious psychiatric disabilities. The truth is, as I think most people would know just from their own lives, the best way to learn to be an adult is to live in a loving home as a child and see what your parents do or what your guardians do. And for kids who've been deprived of that, it's very hard for them to move on to adulthood. Well, we're constantly trying to figure that out. I think some measures have been taken. We've gotten caseloads lower. We've gotten some of the training for workers a little better. We've, over time, been able to persuade Dcfs to be more careful about taking a child away from his home. So whereas Illinois actually has among the lowest rates of removing children from their homes in the country, which didn't used to be the case. And we've improved measures to get kids out of the system. So that Illinois actually has a pretty high rate of children being adopted, children being placed in guardianship. But for those kids who are left in the system, which still is about 14,000, 15,000 children, we have not had much success improving services and conditions. Some, but not much. So it's still a struggle. To have a bureaucracy as your parent is a bad thing for most people. And it's just hard to make that any better for most of the kids. That's a very interesting and difficult philosophical question. I mean, I think we can all come up with extreme cases where a parent really is on the verge of killing a child from physical abuse, where we would want the state to be able to intervene. But many of the cases that Dcfs takes are much closer calls than that. And in those cases, I think there's reason to think the state may be doing more harm than good much of the time. And so I believe as a civil libertarian and as a parent, it ought to be very difficult, even more difficult than it is, for the state to take away somebody's children. I still think Dcfs has too much power. Well, there are various things that define parental rights, but the main parental right is that you have custody and guardianship of your children until there's a reason to take it away. And so most of the rights of parents are defined in reverse by limiting the power of the state to remove your child. But unfortunately, as we were talking about, a lot of those things are fairly vague. You know, what is child neglect? What does it mean that there's a necessity to remove a child? And in practice, I mean, for example, there was a downstate court that used to routinely take away kids when a parent smoked pot. You know, now the criminal law prohibits that. But there's a lot of good parents who smoke pot or who have a drinking problem or who have some other issue. You know, I think we ought to be clearer, and we've worked to try to be clearer, but there's still a long way to go, to require real danger to the child before a parent's rights can be changed and the state can intervene. And I still think it's too easy for the government to take away people's kids.